Good afternoon. I'm happy to say good afternoon again, actually. I'd like to welcome you to an Oak Harbor City Council workshop meeting. Today is August 26th, 2020, and our meeting today starts at 2 p.m. So welcome back. And due to COVID-19, there will be no physical meeting location per Washington Proclamation 20-28. The meeting will be or may be viewed live via YouTube. To listen to the live meeting, please call 623-404-9000. And we'll start our meeting today. We have 2 o'clock opening. Item number A is council training from our very own insurance authority. Today's training is presented by Ann Bennett, the Executive Director of Washington City's Insurance Authority. I think this is very timely since we have a new counselor with us, and it's good to hear this update or this information periodically for all of us. So without anything else, I'd like to turn it over to Ann Bennett with the Washington City's Insurance Authority.
Well, go ahead.
Mayor, if I might just add a couple remarks about WCIA. Ann and I agreed that I would help tee it up. I've worked with Ann for, I'm sure it's been at least 30 years, and with the Washington City's Insurance Authority since their inception in 1981. And I can't tell you all enough good things about what WCIA does for all of its members around the state. You get in a clear advantage in terms of amazing service from WCIA by virtue of them being a risk pool that's governed by member cities and other public entities. And it's just been such a pleasure to get to work with Ann and all of her staff, whom I've come to know well over the years. And one of the many things that WCIA does for its members is assist with trainings. And we just thought this was a good opportunity to pause and provide training, because you've recently appointed a brand new council member, and I think there's at least one other that's recently come on to council, but also for the reason that it's always good to have a bit of a refresher for everyone. So with that, I know Ann is here and she has a PowerPoint, and we're going to tag team this a little bit, but I'll let Ann go ahead and start in. Thanks for giving us your time today, Ann.
Well, thank you so much for having me, and thanks for the kind words, Grant. I'm going to go ahead and share my screen so we can get started. As Grant mentioned, I have been with WCIA 24 years, actually, almost exactly in July. Before that, I was with a major insurance carrier, and I was also with a large corporate insurer. So I've seen insurance from a variety of perspectives. And I have to tell you, risk pooling is one of my favorites, and that's why I've stayed so long. So I'm going to tell you a little bit about WCIA, then we'll get into some do's and don'ts. I will say I heard from a few council members, I'm a little heavy on the don'ts. And I think that's because of my claims and litigation background, but I promise there's some do's in there as well. I will also be pausing after each slide for questions and or comments. I think Grant's going to comment on some of the slides, and then we can get questions, because it's hard for me to see you if you have a question on something I'm presenting. So let's go ahead and get started. So Washington City's Insurance Authority, as Grant mentioned, is a self-insured risk pool. We are an organization that is a public entity created by our members and run by our members. Back in the 80s, it was an insurance, what's called a hard market. You couldn't get insurance. And it's interesting because right now the same thing is happening out there, that for some reason insurance companies don't like public entities because they can't make money on them. So that's the birth of risk pools. Over 80% of municipalities nationwide are members of risk pools. We usually don't have the really big cities, like a Seattle. We wouldn't, they wouldn't join us, but we have mostly medium-sized cities. And around you in Oak Harbor, we have Anacortes, Mount Vernon, La Conner, Coupeville. We pretty much have you guys surrounded. So we have a lot of the cities in Washington State. We've got 163 members right now. Last year, we actually added 10 more members. So we continue to grow. We've been around a long time, and we have the strongest assets of any risk pool in Washington State with over 165 million assets. Every single member has a vote on our full board. So every single city appoints a delegate to serve on our board. And they vote in coverages, they vote in our budget. So it is a very member-centric organization. Any questions? What we provide for you in Oak Harbor is $25 million per occurrence of insurance for all your liability, auto liability, general liability, employment practices, errors, and omissions. One thing I learned in the insurance industry is when a claim or a lawsuit comes in, the first thing that they're looking for is, how can I deny coverage first and foremost? That is not the mission of WCIA. The mission is to make sure that we can cover you. I can't say everything's covered. We do have exclusions, but the idea is I'm going to look for ways that I can help. And that's very different than the industry as a whole. We also purchase insurance for our members, like property, first party, auto, boiler and machinery coverage. As part of our liability coverage, we give you cyber coverage. We also give you pollution liability coverage. And that pollution was just added this past year. And crime and fidelity is something that we have a group insurance for and all members can purchase. And that crime fidelity actually satisfies your public bonding requirement. So the crime fidelity kicks in anytime there's a requirement for bonding, and it's actually easier. I've been told by other city managers, it's easier to collect on crime and fidelity than it is on bonds. So it's actually a bit broader coverage. Aside from the insurance, we provide insurance services. So there's a staff of 21 that I supervise. I report directly to you, the members, and so do my employees. We are 100% your employees. We don't work for any other entity. So we provide claims, risk management, and training. And I know a lot of you, or a lot of your staff, have attended a lot of our trainings. We also do risk management audits. We have what's called a compact that all members agree to abide by certain risk management practices. And the idea is you're pooling your money together. And so you want to know that the people you are pooling your money together with are ensuring best practices in terms of risk management. It's always interesting in the years I've been with WCIA, your neighbors are watching. And I often get phone calls that say, hey, did you see what happened the other day at this location, or have you heard about this? So you are, not only looking out for your liability, but your fellow cities and your fellow municipalities. My dollars are tax dollars. I am a public entity. So if we're paying out money, we're paying out taxpayer dollars. And we like to be good stewards of that money, and we like to make your communities better through risk management. So, Grant, did you have anything that you wanted to add?
The only thing I would add, thank you, Ann, is just that my experience over the years with WCIA, in the instances where cities do get claims or do get sued, is WCIA has at its disposal outstanding defense lawyers that have specialty practices in things like employment law, personal injury, police liability and all the other areas. And so we, when our cities do get sued, we work together with defense attorneys that WCIA appoints, and they've been amazing to deal with. And I know from experience that the success rate in defending claims is incredibly high. And I can't tell you the percentage, but I know that when we get assigned a defense lawyer, we're getting someone good that has special expertise in the area that we need.
Any other questions? All right. So let's get into the meat of this presentation, which is common liability exposures that you can create as a council. So we're going to talk about each of these areas. I'm going to give you some examples. I tell war stories because my background is in claims and litigation. I will not name names, and I'm happy to say that Oak Harbor is not in any of my examples. So sometimes I find when I tell war stories, people say, that's us. It's like, no, it's not you. So I can tell you, you have not made my examples. And I hope after this presentation that you will never make my examples in this training. So now for some good news. I'm going to start out with some good news. You as a city council person and as an individual receive an absolute immunity for your legislative activities. So when you are adopting budgets, when you are passing ordinances, resolutions, when you are on the dais together legislating within the context of a council meeting and within the scope of your duties as a council, you have an absolute immunity. You cannot be sued for doing your duties as a council member. And this is a very strong immunity. One of your neighboring jurisdictions actually had a case many years ago involving their designation of an area as a historic district. And a landowner was not happy that the piece of property that he owned could not be developed the way he wanted to under the new zoning of a historic zone. So he sued every single individual council member. And we immediately assigned counsel, and we wrote the letter saying, hey, you can't do this. They have absolute immunity. You can't sue them individually. Didn't dismiss. We brought a motion, said, we've warned them, we've told them, not only do we want them dismissed, but we want sanctions. So the court read everything, read the briefing, and said, absolutely, they have absolute immunity. You had no right to bring this lawsuit. And not only was the lawsuit dismissed, the individuals, sanctions were ordered, as well as our attorney's fees. After that, because there was a hope that the council members would get cold feet and reverse their decision, he appealed that decision to the Ninth Circuit and said, I'm just going to keep the heat on because maybe they won't run again and I'll get a different decision. Well, the Ninth Circuit hammered that person and awarded over $100,000 in sanctions, plus all of our attorney's fees in the meantime. So that should give you some idea that when you are doing what you're supposed to be doing on the dais and legislating, you have an immunity. Grant, did you have anything that you wanted to add on that?
Thanks, Ann. Just one thing. Heavy emphasis on when you're acting within the scope of your duties as a elected council member. And sometimes there's questions about, well, am I stepping outside of that role, or am I getting close to the line? Those are the times when I think it's appropriate to pause and feel free to ask questions. Ask questions to your legal counsel. Ask questions even to MRSC or WCIA. There's a lot of helpful resources out there, but it's key to achieve that absolute immunity. You need to be working within the scope of your duties. A very recent incident where a public entity got a huge black eye was just a decision this last week in Stevens County where the three Stevens County commissioners were sued by the prosecuting attorney's office for misspending money that was to be earmarked for the homeless. They went outside of the bounds of what they were to use the funds for, and I think it involved about $130,000. And as a result, Spokane County Superior Court just issued a decision, and you can read about it in the spokesman review. I don't think I can share my screen, but the decision was written about on the MRSC website, where as a result of claims being made against their fidelity bond, there's a statute that says that they are removed from office. So the consequence of that is huge and severe, and there's a dispute about whether the judge could really order that these three county commissioners can be removed from office. But that is essentially what the order of the court says at this point in time. So it'd be not much fun to be in Stevens County right now. And in fact, the prosecutor has said if the county commissioners come in to do their job, he's going to prosecute them and hold them in contempt. So those are the kinds of situations where when elected officials step outside of their role, only bad things can happen.
So we have a question from Councilor Servadius.
Thank you, Mayor. So I'm curious, this slide reads, individuals can receive absolute immunity. I'm getting a lot of feedback. I'm guessing Chamber One's mic is on. Thank you. Could that read individuals do receive absolute immunity or can? The reason I ask is we had a land use decision that came before the council not too long ago. And while acting in our legislative capacity and trying to interpret our code to the best of our ability, some people voted yes, some people voted no, but we actually received instruction that we were not immune, that we could be personally sued based on how we voted in our interpretation of the code. So I'm curious, this says can receive. Can you give me a little more assurance there that they do receive as long as they're putting forth their best effort working in their legislative capacity?
Grant, I'm not familiar with the particular topic. I can talk in general. I say can because nothing's guaranteed in the courts. And so my experience is that each decision is fact specific of the court. So that's why I say can and not will, because it depending upon the facts, the court can find you are within the statute that grants you immunity. So it's all fact specific. So I'm going to kind of defer to Grant on, I don't know the specifics of that land use hearing and why that advice was given. Yeah,
and I was not involved in that hearing or that process or representing the city, but I think in answer to Councilmember Servadius's question, at least in general, there is a statute that provides for absolute immunity, but the case law that interprets it does have a set of criteria that you have to meet. Things like showing that you acted in good faith, things that like that you acted within the realm of what you're authorized to do. And certainly one of the things that a council is authorized to do is to interpret its own ordinances and codes. But Ann's completely right. To achieve immunity, it's going to depend upon the facts and circumstances of each case, and it's not always black and white, because courts can apply the factors that are in the case law, some different than others. So it is a case-by-case basis, but in general, immunity is available for most types of actions that councils take that's within the scope of their duties.
Okay, thank you.
All right, I'll go on to the next slide. Speaking of land use, we're going to talk a little bit about how land use areas are where councils can get into some trouble. And one of the areas I'm going to start with is your role. Are you acting in a quasi-judicial role or in a legislative role? And that's where your previous question is timely, because I don't know what role, it sounds like you were working in the legislative, not quasi-judicial role, but there are areas when you're acting quasi-judicial that you can get into trouble. I will say, I know you have adopted a hearing examiner. That's one of our recommendations to avoid liability, because this is such a tricky area for councils, because when you're sitting in a quasi-judicial capacity, you are acting as a judge. And when you're acting as a judge, you must be completely fair and impartial, and you must be looked upon by a reasonable outsider as having no bias. So it's not whether you think you can be fair and impartial. It's not whether I think you can be fair and impartial. It's a reasonableness standard. So someone from the outside in, looking in, will say, yeah, I think that person's fair and impartial. And sometimes that can be difficult, because you're legislating. You have constituents who talk to you. They come to you and say, I don't like this project. I like that project. I need you to be my advocate. And when you're sitting quasi-judicial, you can't communicate with the proponent or opponent of the project. So it puts you in a very precarious position where someone from the outside could say, hey, I saw you talking in the grocery store with this person. How can you be fair and impartial? And that's where we get a lot of challenges to land use decisions. And I'm sure Grant can talk to many where people have come in and said, well, you can't be fair and impartial. In fact, I knew of one where it was the leader of an anti-growth group ran for council and then sat on a decision and said, I can be fair and impartial, even though they fought this developer the entire time. And so if you can't be fair and impartial, you must recuse yourself, or at least identify that you've had communications and why you're not, why you consider yourself fair and impartial, or it's not an issue. I think with the use of a hearing examiner, you're going to avoid a lot of that because hearing examiners know the rules of evidence. They can they're not having to deal with the public in your community, and they will make findings of fact and conclusions of law. And that's very helpful because it avoids the claim that decisions are being made and they are arbitrary and capricious. That's often what we see. So often at times with land use matters, you will have a land use decision that you're making. And if the person suing you disagrees with it, they will say, you know, you have violated due process rights, you were arbitrary and capricious, and they can also seek damages. And that's where WCIA comes involved, is when there are claims of damages as a result of that land use decision. And that's why we advocate very strongly for hearing examiners. And I'm extremely pleased that the city is using that system. So there may be times when you're sitting quasi-judicial, and when you are, I'm sure Grant will let you know you're sitting in a quasi-judicial capacity right now. They're not going to let you go into that role without understanding what you're being asked to do. So Grant, did you want to add anything on this one?
Just that with the adoption of a hearing examiner system, as I understand Oak Harbor has done, most, if not all, of your land use decision making that is quasi-judicial in nature is going to be decided by a hearing examiner, and any appeal of a hearing examiner would be to Superior Court. I do know over the years that it's been difficult for some cities and towns to agree to want to use a hearing examiner, because as an elected official, it's understandable that you have an interest in what's going on in your community and how the land use and development process goes. But it's difficult at times to be able to do as clean a job of holding quasi-judicial hearings as a trained hearing examiner. In talking with particularly a couple of the litigators that WCIA hires to defend cities on land use matters, I've come to understand that the vast majority of decisions that get overturned at the local level are those cities and towns that have not adopted a hearing examiner, and the percentage of cases that are upheld is quite a bit higher. No offense intended to councils, but it's just simply not the area that elected officials have been trained to operate in. So as a result of risk management, I think WCIA is very supportive of cities that have adopted a hearing examiner system.
So we have a question from Councilor Goebel.
Any other questions?
Yes, I think we have a question from our Councilor Goebel. Councilor Goebel, can you hear me there?
Hi.
Here we go.
I have a question. Can you give an example of when we would be sitting quasi-judicial? I know you said that we would be told when we are going into that kind of position, but could you just give an example of when that would happen? Is it just for land use, or are there other times?
Land use is by far the most frequent area where you would be sitting essentially as a judge and listening to evidence and making findings and fact and conclusions of law. But most cities, even those that have adopted hearing examiner systems, do have some what I guess I would call remnants in their code, some areas where an appeal of a decision by staff is to the city council. Oftentimes it's things like appeal of the denial of business licenses or the issuance of things like adult entertainment permits and special areas or like a taxi cab license. And I haven't had a chance to go through Oak Harbor's code carefully, but I would be surprised if I didn't find a few areas where the appeal of a decision is to you as a council as opposed to a hearing examiner. Typically, the hearing examiner is hired to handle mainly land use type of decision making.
Gotcha. Thank you.
Okay. So continuing on the land use track, even if you aren't involved in the decision making as far as hearings and land use appeals, you can still create liability for the cities. And I'm going to tell you about 3 cases. And unfortunately, the first one I'm going to tell you about was one of ours. So it's a case called Westmark versus the City of Burien. And I see Grant smiling because this has been an ugly case for many years. And I'll give you some background and kind of what happened. The City of Burien incorporated in 1993. Prior to incorporation, King County was doing a lot of approval of apartment buildings in that community. And one of the reasons that Burien incorporated is that they didn't want to be an apartment community. They wanted to be a single family home community. So in the midst of incorporating, prior to the city incorporating, the Westmark Group filed an application for its multiple 3 huge apartment buildings on a very steep slope in Burien. So think back, this is 1993 that this goes on. So some of the laws that are in play now aren't necessarily gonna apply here. But what happens is there's a very long delay. This case went to trial in 2005. If that gives you an idea of how long the delay was in processing this application. There were all kinds of environmental issues going on, but throughout the process, there was communication by very vocal council members saying, we have to stop this project. Staff has to stop this project. This project can't go forward and we need to do something. So throughout, we're arguing, but the delay is because of this, and the delay is because of that. And this is under some old land use, so the delays could go on. Now you've got some timeframes. But the problem was nobody cared about our reasons for the delay. All they heard was, no, the city council didn't want this to go forward. So into this process, multi-years of litigation, we actually come up with a settlement. And WCI agreed to pay $250,000 to the developer. And there were other things that the council agreed that would happen from the land use side of things, that they would allow these, they would issue a certain determination. So that was part of the settlement. So we issue the check. We go ahead and have all of these signed releases, and we close our file. What ends up happening as this is going through the process, the city council says, no, we don't want you to do that. No, we won't let you do that. No, this has to be stopped. So what happened is the developer went to court and said, I want to enforce this settlement agreement. And so when that lawsuit was brought, the council said, well, you can't enforce it because guess what? We never approved it in open session. We never approved it in open session. We talked about it in exec session, but because it was never in open session, it's invalid. And the court agreed. And so we ended up back in court. And a jury heard that fact, along with all of the other delays, all of the very vocal, we don't want these apartments. And what ended up happening is the jury hammered the city with a $10 million verdict. And what happens when we get a $10 million verdict? We appeal it, of course. We're going to appeal it. And I'm thinking, well, the Court of Appeals has got to see that there were a whole bunch of other reasons for the delay. I'm sure, the council wasn't very good, but I'm sure the court will understand there were other reasons. The court didn't understand that. They slammed the city in the decision. And anyone who's read it, it is brutal. Basically saying the council was interfering and this was an agenda and they tortiously interfered with that business. And they upheld the $10 million verdict. So yeah, that was a lot of money that came out of Burion's members. All of the members contributed. And so not only did they get the 10 million, but they also got their attorney's fees to the tune of $6 million. So overall, that was a $16 million hit against this risk pool. So we don't like when that happens. And that's why I tell that story, is your interference and decisions can be very, very costly. Another decision that came out, and Grant will like this decision, it's called the Mission Springs versus City of Spokane decision, and I call it the city attorney's decision. City of Spokane, not a member of our risk pool. And what occurred here is Mission Springs was a very large development that was very controversial and that citizens didn't like it. However, it met all of the requirements of their land use code. So it went through the process and the grading permits had been issued. Citizen groups were coming to the mayor, coming to the council saying, you have to stop this project. You have to stop this project. So the mayor invited all of the citizens, did not invite the developer to a council meeting, and it wasn't on the agenda, and brought up, I would like to know the status of the Mission Springs project. So the planning director gets up and says, the grading permit has been issued and they're starting work. The mayor said, do not allow the work to continue, do not issue any further permits, and revoke the permit that you issued. Now, I'm going to tell you that when someone on your council did something like that, I know what Grant's going to do. Grant's going to stand up and say, we need to go into executive session. He's going to say, I need to call a quick executive session. You'll go in and he'll explain why you should not make this decision. Now, for whatever reason, I have no idea why, the Spokane city attorney decided on the record to say, Your Honor, members of the council, you can't do that. You can't do this. It's illegal. It's past the time. You must allow this to progress. or you will be breaking the law. And that's all on the record. So what do you think happens? Mayor says, don't issue the permit, revoke the other permit, do not let this project. We are ordering you to do so against the advice of legal counsel. So what happens? Developer goes to court. The court found, and this is a good example, no legislative immunity, because what they found is you were told you were outside of the law. You are acting in bad faith. You knew your city attorney told you you couldn't do this, and you did it anyway. So not only did they not have legislative immunity, but the court held them liable under state and federal law. And this is important because the decision said you acted in bad faith, intentionally, knowingly breaking the law. No insurance company, including me, can insure knowingly intentional violations of the law. So if somebody tells you this is illegal, you can't do it, and you intentionally break the law, insurance is for accidents and misunderstandings. It is not for intentionally breaking the law. And so their carrier denied coverage. So all of them were on their own. Now, I don't know what happened to this case. I've heard there were six-figure type money being, bandied about, and somebody paid it. And I've never heard who paid this eventual settlement. But what I will say is when, Grant says, stop, we need to go in executive session, stop, go into executive session. If your city attorney says this is not within the purview of the law, you want to listen to your legal advice. It's one thing most attorneys, and I think Grant will agree, will say, well, it's a gray area. Gray areas, it could go one way or the other. However, when somebody tells you this is against the law, it's against the law. So that is a very scary case that I think all councils should know about. The next one is actually an interesting decision because it's a favorable decision for Kitsap County, and this involved a large development that was I say mobile homes, but that's not the right term. So it was a big mobile home development that had a lot of issues with wetlands, and there were a lot of Department of Health regulations. And it was taking a long time. During this process, a couple of county council members were issuing emails to constituents who didn't like this project. And they said things like, we're going to do everything within the law to make sure this never happens. We understand that you don't want this. We're working on it. We're looking for loopholes to get this stopped. So all of these emails were out there. And what happens when things are taking a while, often people will file public records requests to find out what's taking so long. And in this case, Woodsview got these emails. And they said, aha, this is why it's taking so long. It's because there's some bad faith in the background with these Kitsap County council members. So there's bad faith, and they're influencing this process. The good news is that every single person working on this project said, I never saw those emails, and no council member ever came and talked to me. And so what happened was they found the delay was legit. It was legitimate to Department of Health, and that there was no bad faith on the part of the staff because they had no idea that these conversations occurred, and none of the council had ever come and talked to them. So what I would say is you have to be careful, what you're saying, because my suspicion is if there was a public records request and Woodsview got all the information where it said it's the Department of Health that's delaying, it's the Department of Health, there probably wouldn't have been a lawsuit. They filed the lawsuit because they thought they had the smoking gun of interference. And so I would say be very careful in these projects that you're not interfering in the process, and that staff can be evaluating things and has a clean record of their objective decision-making. Grant, did you want to add anything?
Just two things, and one of the guiding principles that I've always tried to communicate to staff who are evaluating applications for development is if you're going to impose conditions or special requirements, please point in your code to or your other standards to where that's allowed. And in cases where there isn't a section of code or adopted standards that supports the decision to impose conditions, we better take a closer look at it, because that's an area where cities can get into trouble in the permitting process. The second item is back to the Mission Springs case. One of the things I think that puts city attorneys in a really awkward position is when a elected body or a mayor that's chairing a council meeting starts off into an area that is a high risk area that could expose the city to liability, and trying to make the decision as the city attorney, do I interrupt and speak up now and say you can't do that or that's illegal? Or do you squirm enough and do enough body language so that somebody pays attention to you without saying anything, so you can say, I think we need to recess into executive session? And over time, I think a line of communication needs to be developed, so we can do our job to help counsel you, but in a way that doesn't come back to bite the city by making a record that's not helpful to the city. So there's times when squirming in your seat as a city attorney does have significance.
So we have a question.
Thanks, Ann.
Question from Councillor Servadius.
So, Mr. Weed, what would be the exception? Why would we, and I appreciate that, we'd want to go into executive session, but I thought it needed to be pending litigation, not potential, or what would allow a council to recess into executive session?
It's going to, that's an excellent question, by the way. It's going to depend upon the particular circumstances, but there's an exception in the Open Meetings Act where council's allowed to discuss exposure to liability in legal matters with legal counsel if the outcome could relate to a loss to the city or to have adverse financial consequences. So it doesn't have to be a direct threat of litigation, but there has to be a reason, or at least a reasonable basis for a potential claim against the city if a particular action is taken.
Okay, thank you.
You're welcome.
Okay, I'll move on. Next area of potential liability is personnel. And this is an area that I've seen some councils get into trouble. Your role is legislative, is to set policies, to set budgets, and to look from a legislative perspective at the personnel of the city. What you don't want to do is stray into the executive's role, into the mayor's role and the city administrator's role. And I say that because they have the ability and they have the power to manage employees, hire employees, fire employees, and discipline employees. And in personnel law, you can be held personally liable for employment actions. So I, as an executive director with my employees, I can be held personally liable for the decisions that I make with regard to an employment action. Personnel law changes constantly, and you can't be expected to be on top of that. That's why we utilize employment attorneys all of the time to advise our members on what is the status of the law. I can tell you of an example of one of our members where a city manager fired a department head for theft. Now, you would probably think that if an employee stole from the city, firing that employee is probably a darn good idea. Well, there were council members who were big fans of this particular department head who came to council and said, we disagree with the decision. We want to overturn the city manager's decision. we want a hearing into why you decided to fire this employee. City manager said, no, it's within my purview. It's within my rights to do so. And I don't want to defame the employee by having an open meeting on what my decision. If you want to come to me individually, I'll explain my decision, but that wasn't good enough. And what ended up happening is there was so much fighting over this that the employee filed a lawsuit, and the city came apart at the seams because there were the pros, the cons. The council was fighting in every council meeting, wanting more information. And in fact, the lawsuit was so contentious and there were so many leaks from the council to the plaintiff that we cut off all communication with the city because we could not trust that our defense and our strategy would not be told to the other side. There were multiple public records requests that cost hundreds of dollars in staff time, probably thousands of dollars in staff time. I spent $1 million on this case with all the depositions, with all of the motions, going to trial, only to have that decision upheld. It was upheld. It was a good termination. But that city was fractured, and it was fractured for years afterwards, all because there was a disagreement. And the idea is the city manager fired an employee, and they fired him for the right reason. And starting to bring that into the legislative role can create all kinds of harm for our cities. And I've seen it. That's just one example. I've seen quite a few where it doesn't assist for a council member to become involved in a personnel matter. Grant, did you have anything you wanted to add?
Thanks, Ann. Just one comment. Just one red flag that should come up for elected council members is in the event an employee of the city comes to you and wants to talk about the status of their employment, that should raise a red flag with you and should be avoided. If there's concerns that you have about particular personnel, the appropriate thing to do is to bring those concerns to the attention of the city administrator or mayor.
Mm-hmm. I'm going to kind of slide into this slide as well, and then we can answer all questions on personnel because it's really along the same topic, and that is harassment and discrimination. You as city council members should know the law. You should know harassment and discrimination. You should know the city's policy. You are held to that policy. You are not allowed to harass, discriminate against city staff, one another. I've had complaints amongst council members. So know the law, get training. If you haven't had training recently, I suggest, we've got it on our website. You can, as a member, watch anti-harassment training. And every single one of our members have harassment and discrimination policies. Where you can really help is if, you witness behavior, if you see behavior that you believe violates the policy, you need to let the mayor know. You need to let the city administrator know. If an employee comes to you and says, I am being harassed, but I don't want you to do anything about it. And we all know that. I personally have had people come to me and say, you know what, I'm being harassed. When I was a manager, I'm being harassed by this manager, but I don't want you to do anything. Well, guess what my answer was? I have to do something. You're a city official. You must report the behavior. So if you are aware, that is occurring, you have a duty to act. And your duty is to go to the city administrator, the mayor, and say, I have been made aware. When you are aware of it, there are short time frames. Cities must investigate. Cities, all employers must investigate the behavior and determine appropriate action if it needs to be taken. So I have had situations where employees have said, well, I told this person, I told a council member and nothing happened. Nothing was done. And then the council member says, well, I'm not the person they should report it to. The policy says, go to HR. That's what the policy says. I just, that's not me. Well, guess what? You are a city official. So nothing is confidential. People can't be confidential in harassment and discrimination. And you cannot keep things confidential yourself because you are a city official. So Grant, did you have anything to add?
Just one thing, Ann. On a positive note, one of the wonderful benefits that WCIA provides is when a city gets into a situation where there's an obvious risk of potential claims or litigation by personnel, they are willing to assign pre-defense review, pre-defense counsel by well-trained, well-experienced labor and employment lawyers. It's a service that you aren't going to find elsewhere. And it's been of tremendous benefit to many of our public clients to have the ability to consult with a labor and employment specialist to develop a strategy in how to keep from making things worse, and oftentimes how to keep from actually having the lawsuit filed, and how to counsel people who are having to deal with the employee that feels that they've been harassed or discriminated against. So it's a service that's available, and it's a service that I've found been much appreciated because, as Ann mentioned earlier, this is an area of constantly changing law, and to have somebody that's got a very high level of experience in this area available to you is a really beneficial thing.
So we have a question from Councilor Servadius.
Mr. Weed, I wanted to dive into that a little bit more. So hypothetically speaking, what if an employee had a grievance that was directed at any of those individuals you just named, HR department, city administrator, or mayor? If they don't feel they can go to those individuals, if that was where the concern lies, what do they do?
One option would be to come to the city attorney. And another option would be to come to the council president or the mayor pro tem. If it's all of those individuals that you listed, that would be my recommendation.
Okay, thank you.
Next slide is kind of a confusing area, and I'll give you an example that I think helps explain negligent misrepresentation. And so where this comes into play is you are a speaking agent for the city. And so you can make a specific promise or an assurance to someone. And if you make that promise or assurance and someone relies on that promise or assurance, yep, I relied on it, and later finds out it was wrong and was damaged because of it, you can have what's called a negligent misrepresentation claim. So I'll give you an example because that's a lot of legalese. So one of our members, their downtown is all made up of cedar shingled buildings. So all buildings downtown are cedar shingled. Well, a business owner approached the mayor one day and said, hey, the cedar has to be replaced. I can't afford it. Is there any way I can just take down the cedar and maybe just put up some plain old wood siding? It's so much cheaper. My business isn't doing so well, and I can't afford this shingle. And so the mayor said, well, gee, you're a valued member of this city. We want your business to stay. Yeah, go ahead and do that. So this business owner takes down all their cedar. They put up their siding. And what do you think happens halfway through that project? The building official comes out and red tags it and says, you can't do that. This is against code. You can't have siding. It has to be cedar shingle. And the business owner said, wait a minute. The mayor told me I could. The mayor said it was fine. That's what I mean by negligent misrepresentation, because he then filed a claim saying, hey, you cost me money. I have to take down all of this citing and now it's worthless. So the claim that we paid on was for the labor to take it down and all of the costs that he had incurred to put it up beforehand and the cost of the materials as well. So what I would say is if you're approached and asked a question, the best thing, if you know the answer and you're solid on the answer, you can give them the answer. But if you're even hesitant at all, you can say, I don't know. And I'll be honest, I say, I don't know a lot. But my follow-up is, I don't know, but I know the person that does. And that's where you have your staff. You have city staff that are experts in a lot of the questions that you may be asked. So if somebody comes to you and says, hey, can I change from cedar shingle to siding? You can say, boy, I don't know. Let me get you to the person who does know. And sending emails is fantastic. To the staff, I was approached by the citizen. They have a question. Here's their contact information. What I will say is do not take matters into your own hands, because that can be a recipe for disaster in terms of making representations or guarantees. And then you come to find out later it's not allowed under your code, or it's some other type of mistake. And then the person can come back and say, I relied on this. I relied on your assurance. And what I usually find is city staff is more than happy to help. And I always think it's best if you just say, I'm going to get you to the person who can help you, so that you're not trying to take this on yourself. Grant, did you have anything?
Just to add that as an elected official, you aren't expected to know every part of your comprehensive plan or your zoning regulations or your building codes and other ordinances and development standards. And that's one of the very best reasons to say to a constituent, I need to refer you to somebody in the planning department or the HR manager or whatever the case may be.
I don't hear any other questions, so I'll move on. Defamation. This is another area where there can be some confusion. What I will tell you is statements, opinions regarding legislative concerns. Hey, you're there for a reason. You're there to debate. You're there to have vigorous discussions on topics that affect your community. And, coming out and talking about that on the dais is important. And so you do have quite a bit of leeway with regard to, when you're making statements regarding legislative concerns, you have quite a bit of leeway and people can't really sue you for defamation. Where this can get into trouble is individuals. And I say careful because there are times that you can defame people, but it's rare. And any untruth can give rise to liability. So there are times when it's a public official, and the case law basically says, say it's me, and you have real concerns about me. I'm a public official. And so if you are talking about me and it's a matter of public concern, and it's true, then you probably won't be sued for defamation. However, if it's just a staff member or a private individual, if there is any untruth, you may open the door to defamation. And you only need to look at a city to the south of you, Seattle, and see how many defamation claims were filed a couple of years ago against that mayor and against some council members. And so when you start talking about individuals, you need to be very, very careful. And what I often say is use the golden rule. If you can't say something nice, don't say anything at all. The other area is also, when are you in the course and scope of your duties? We had a case where a council member was very vocal against a staff person. The staff person left the city and went to another city. And that council member decided to inform the other city via email how horrible that staff member was when they worked with them, and use things like liar, cheat. And a lawsuit was filed saying, you're defaming me. What do you think we did when that lawsuit was filed? I didn't give them coverage. You know why? That's not within the course and scope. You, on your private time, not a legislative concern, took it upon yourself to defame that person to their new employer. And so that council member had to pay for their own defense of that defamation lawsuit. So again, I caution you, be very, very careful with individuals. And I say, if you can't say something nice, don't say it at all, and use the golden rule. Grant, did you have anything?
Just one thing, Ann, thank you. When you sign up for and get elected as or appointed as an elected official, the same rules don't apply to you. When it comes to the public, the law puts the bar a lot higher in terms of allowing you as an elected official a cause of action for defamation. And oftentimes I've had council members come to me and say, well, this citizen just lambasted me and said all kinds of things that aren't true and that were harmful to me in a public city council meeting that was recorded and televised. Do I have an action for defamation against them? And oftentimes the answer is going to be, unless you could prove that they did so with malice and intent to harm you, and that the untruth was egregiously false, the answer is oftentimes going to be no. So it doesn't work the same way for public officials as it does for the things that you might say about a private individual. It's just the way the law is written. There's a expectation, essentially, that elected officials are going to have a thicker skin when it comes to being publicly criticized. So keep that in mind. Most of you probably know that, but that's just the way it is.
And I'll also add, you can defame whoever you want in elections. Every time I do this training, somebody asked me, well, what about elections? It's like, you guys can defame whoever you want, your opponent. And that's one area of law where they said, you can't sue for defamation when you're running for election. Any questions? All right. Public Works. I'm going to give you a little education on the law before I get into this slide. In the state of Washington, we have something called joint and several liability. And what joint and several liability says is that if a plaintiff is negligent free and they sue multiple defendants, they can collect against any one of those defendants as long as that defendant is at least 1% at fault. So I'll give you the example. Oftentimes we'll have lawsuits come in against cities where a person is in a crosswalk legally. They are hit by another car. That car has no insurance. So what they do is they sue the city saying that there was somehow a negligent design of that crosswalk. And the hope is that they can get at least 1% negligence against the city so they can collect the entire amount of their damages. Now, what's really tricky is a jury never hears that. So oftentimes a jury will say 60-40 or 2% the city, 98% the car, but who pays for the whole thing? The city. So these cases are brought quite frequently with very catastrophic type injuries or deaths. So what often I ask of my counsels is to not politically engineer. And I use that term because all of these cases, these road design cases, are brought basically as an engineering malpractice case. So our traffic engineers, their decisions, why they did something, why they put a crosswalk there, is up against the plaintiff's expert saying why their engineering decision was wrong. If you as a counsel take that away and do what I call politically engineering, which is, hey, let's put up a stop sign here, or hey, we'd really like this mid-block crosswalk because people want it. That is political engineering, and that is not using the engineering data that we can defend. So I'll give you an easier example than, the big ugly cases. I was doing this training and a mayor said, boy, Ann, this happened to us. I had a council meeting. 30 citizens came into that council meeting and said, we really need a stop sign at this intersection. People are driving too fast. If you put a stop sign in, it'll save lives. And so against the traffic engineer's advice, who said it doesn't meet the warrants, it's not appropriate, the mayor said, I don't care, I want a stop sign. And so they put the stop sign in. He said, the next meeting, Ann, I had 200 people saying, how many people are going to get killed from all the backup because you've created a massive conflict because of that stop sign. And that's where most of these engineering treatments are to improve traffic flow and avoid conflict. And that's where you can create conflicts by making those decisions. Crosswalks aren't force fields, and more people are killed in crosswalks than they are jaywalking, believe it or not. So what I often say is, if you are in a council meeting and someone says, I'm in public comment, this is dangerous. And I was in one where somebody said, how many children have to be killed before you do this? Afterwards, nobody bid on it, but afterwards the council went to staff and said, can you look into this and explain this? Just outside of the council meeting, you want to have staff look into it and let staff respond as to why those decisions are made. And it's usually based on, engineering decisions. Avoid promises, assurances, and inflammatory statements. And I say that because oftentimes you will have a tragic situation occur in your community, and you will have people coming to your council meeting saying, you must do something. And we had a case where a little child, 4 years old, got away from his mom and ran through a crosswalk and was hit by a car. And people came to the council meeting and said, we knew this was dangerous crosswalk. You need to do something. People are driving too fast. And council members in this, after the public comment, were commenting, yes, we need to reduce. What can we do to reduce the speeds? We need to do more for that crosswalk. Maybe we should have never put a crosswalk there. Now, I will tell you, that crosswalk met every single standard. And the driver of the vehicle said the sun was in her eyes and she never saw him, never saw the child. We ended up in litigation, and the council, including the mayor, were called as witnesses for the plaintiff because of the statements they made. And the worst part is that they had to admit, when questioned by my defense attorney, what evidence did you have that there were accidents? There were none. There were no prior accidents. What engineering data did you rely on? What traffic studies showed you that people were speeding? None. So again, you don't want to invite the litigation, but we can make changes. And I will tell you, this is an area where oftentimes we'll bring in one of the attorneys to help you decide, what are we going to do? What's our response going to be? Because I know it's very, very difficult when your constituents think they have a solution that they want you to implement immediately. And it does need study, and it needs an engineering treatment to it. Grant?
I'd just add that in cases where you can't document through sound engineering judgment, sound engineering principles, and conformance with the Manual on Uniform Traffic Devices, the MUTCD, you can put the city in a vulnerable spot to approve changes on roadways that don't meet those standards, and it puts your city attorney in a really awkward situation where council members ask the city engineer to do something that isn't warranted by the design standards, and then they turn to the city attorney and say, well, that's going to be okay, isn't it? Or is that going to create liability? And you don't want to have to be in a spot where you answer that question on the record. So if there's questions about some of these questions about whether there should be changes made, I think that the time to initially take those up is with the experts, with the engineers and the experts, and give them an opportunity to explain why something might seem on its face to be a reasonable change. But if it's not justified by the standards, to try to resist the temptation to do it.
Any questions? Executive session. This is where I ask you to resist the temptation to share. There's a reason you're in exec session, and so you can discuss matters that, if it's shared with the public, could jeopardize the city. Real estate, litigation, potential litigation. If you think you have a conflict, please recuse yourself. I have a member who has a journalist who is on the city council. And so oftentimes it's a big problem for that journalist to sit in some of these exec sessions because they feel they need to report on it. So we had some very good discussions, and if there's discomfort, that council member will recuse themselves. But I will tell you, there are times when I have had claims and litigation discussed and it comes out of exec session. I actually have had my defense jeopardized where the city attorney has taken the council into exec session, told them my game plan, this is what WCI is going to do. And then next thing I know, I'm in a mediation and the other side knows exactly what I'm going to do and what my dollar amount is that I want to settle at. So please don't do that. And if I find out that's happening and if I know there are leaks, I often won't communicate with that council anymore. So it is an OPMA violation and there can be sanctions. And I do know of examples where council members have violated it and cities have taken action against them. Grant?
Just the consequences of a violation of the Open Meetings Act can result in personal liability to council members. The first offense is up to a $500 fine. The second offense is up to a $1,000 fine. But there's also a provision in the law that can result in an injunction and attorney's fees awarded to the plaintiff that brings a case against a city for violation of the OPMA. And probably worst of all, in egregious situations, if it's a clear violation of the law, you could put your oath of office in jeopardy and be subject to recall. So it is a serious situation. It's one that needs to be kept at the forefront anytime we meet in executive session, that what's said in the room stays in the room unless a majority of the council opts to want to disclose confidences that are in their judgment in the public interest. But it can't just be one individual council member that decides to share something outside of executive session.
Any questions? Well, last but not least, I will say be very mindful of your written communications. And I use this phrase often: email can and will be used against you in a court of law. Email can be misinterpreted. And oftentimes I see some of the most egregious things through discovery in litigation that are written and in email. So know that it is all public information. Your email should be the city's email account that they've issued you. I'm assuming you guys have one. If you have a personal email and somebody sends you a request for city business on that, just go ahead and let them know, this is the account I use for city business. Please don't use my private email address. If you are working on city business on your private computer, that could subject it to search. So often what happens is a public record request will go around and your public records officer will say, do you have any public documents on your personal device, on your personal computer? And you would likely search for it and then sign an affidavit that says you don't. However, there have been some big fights over this, and a Puyallup City Council member actually brought litigation saying, I have a right to privacy of my personal computer and you can't search it. And the answer was, no, they can search the personal computer. You don't have a privacy right. Also, be very mindful of Open Public Meetings Acts through email. You can't have serial meetings where you're building consensus just because you don't have a reply all. If you're, polling one council member and then you poll another council member by email, you can have a serial meeting. And one of our members, WCI does not cover fines and penalties, and Open Public Meetings Act remedies are fines and penalties. And one of our members it had to do with the firing of a city manager. And it was found that they were having what they called serial meetings and building consensus outside of the public meeting, where there were emails going back and forth, there were phone calls going back and forth, and basically they were coming to consensus and showing up at the council meetings, making decisions based on already knowing the answer. They were sued, and the city was hit with $400,000 in sanctions for violations of the Open Public Meetings Act, along with attorney's fees. This is another area you could lose your legislative immunity if you're violating the act. And I do want to do a little warning about Facebook. There's some cases out there that say, your personal Facebook is your personal, but you can have an election or a city Facebook account. So if you have a public-facing Facebook account, know that you have created what's called a public forum. And we just recently had a challenge where the council member had that forum open so people could reply back to that council member and post some of their thoughts. And so it was a dialogue. Well, somebody came in and posted a whole bunch of things that this council member disagreed with and didn't like, and blocked that person. And next thing we knew, there was litigation over the fact that it was a First Amendment violation because it was a public Facebook account that was open to dialogue, and you can't block that individual. Now, you can create an outward-facing account where there's no dialogue and you haven't created that forum. So you can push out information, but just be aware that's out there, and that's kind of new areas that I see could cause some problems. So be aware of that. And again, everything is public record, your texts, if you're out there tweeting, if it's city business, it's all part of the public record. Grant, did you want to add anything on that?
Just that the law in the area of social media and public employees and elected officials has changed considerably over the past 2 or 3 years in particular. It's evolving. And I know our office, one of the other lawyers in our office has done some trainings just in that area for some of our city clients because it's evolving so quickly and we get so many questions. But do be aware of that. And if there's questions about how you're going about it, don't hesitate to inquire. Anne's right. Almost everything that you write, whether it's text messages or emails or whatever that has to do with city business, you should consider is a public record. And so ask yourself before you press the send button, is this something that you would be bothered by seeing on the front page of the newspaper?
Any other questions? Well, that's all I have, and I really appreciate the opportunity to talk to you, and I hope there were some good takeaways for you, and I'm happy to answer any other questions. Otherwise, I just want to thank you for having me.
Well, thank you, Ann, and thank you, Grant. I don't see any other questions at this point, so I think you provided a lot of answers and a lot of good information, and we have some additional reading here in our packet too that we can do. So thank you very much. Really appreciate your time here with us today.
Thank you so much.
Thank you, Ann.
Okay, we'll move on then to item number B. This is your information about a recommended action that I intend to bring to the next council meeting to appoint the firm of Weed, Grafstra and Associates as the Oak Harbor City Attorney for a one-year period beginning September 1st, 2020. We have the background information there, which I assume you've read. You know, in that or from your experience here that this firm, and especially Grant, has been quite involved with our city for many years. They served as our city attorney from October 2012 to August of 2014, and then we've had an ongoing contract with them pretty much ever since. So if there's questions at this time or even at the meeting on September 1, be happy to try to answer those. We've talked about the fiscal impact, and yeah, we've had, again, a good relationship, and I appreciate, Grant, your personal involvement, which so often, I know you've got a lot on your plate, but I know that Oak Harbor has been able to get a lot of your time over the years, and we appreciate that, so thanks. Any questions about this? Mayor Pro Tem.
Thank you, Mayor. This is just, I guess, a comment. I'm sure that Grant wouldn't offer his firm to be of assistance unless he felt like he can meet our needs. And I think it's a wonderful idea. I remember you talking about it to council a while ago, before we hired Nikki Esparza, actually. And I think it's wonderful, and he's always been there when we needed him. So I'm looking forward to having this come forward. Thank you very much.
Thank you, Mayor Pro Tem. Anyone else? Input or question? Okay. We will then move on to development services. We have a couple of sections there. The first is the Housing Action Plan update. And I think for that, and maybe for both of these, we have Kak Kamak, our interim director of development services. Kak, welcome.
Good afternoon. Thank you, Mayor, members of the council. Glad to be sharing this update with you. We have a couple updates, the Housing Action Plan and the Shoreline Master Program. Dennis, our senior planner, is leading that effort, so I'm going to hand it over to him, and we'll stand by for any questions that come up. Dennis?
All right. Can you all hear me okay?
Yes,
good. Thank you, CAC. Good afternoon, Mr. Mayor, members of the council. A couple of months ago, I introduced some of the, basically a kickoff meeting for the Housing Action Plan, described the intent of the plan, some of the early pieces that we were putting together, such as the project charter, public involvement plan, and also discussed the schedule with you. So it's been a couple of months, and I want to just come back to you and describe some of the efforts that has taken place in those 2 months. As you know, we're working with LDC as our consultants who are the experts in housing and are assisting us greatly with pulling this plan together. We are utilizing our $80,000 Commerce grant that we received a few months ago, actually late last year. And the first effort that LDC is working on at this point in time is a housing needs assessment. And that's a big piece of this plan, because what we hope to achieve from this is to analyze our current population trends, look at household and housing characteristics of the city. We're also going to be looking at the income levels, which will be a key element of our effort in this plan, including the cost burdened households, which is a requirement from Commerce. And we're also going to be defining the existing and future housing needs. So there's going to be a lot of elements to the housing needs assessment that we are pulling together. And we will be presenting that housing needs assessment to you as a council. Probably we're looking at October's meeting for a discussion at the workshop. We're also implementing the public involvement plan quite nicely, actually. We pulled together a stakeholders advisory committee of about 14 different members that have representation and have associations with our housing market in the city of Oak Harbor. We have a lot of builders. We have representatives from the local governments, as well as some of the organizations that deal with housing in our region. We had our first stakeholders meetings July 30th, and it was a very good discussion. We had really nice input on what their perception of housing needs were. We also had a discussion on what they saw as regulatory barriers that we have currently in our policies and regulations. And we also had a discussion of where their perception of actually geographic physical growth of the housing market would be for the city of Oak Harbor. We anticipate another stakeholders advisory committee meeting probably sometime in early October, or at least when the housing needs assessment is in draft form so they can have a chance to review it, issue some comments, and we'll bring those comments and the housing needs assessment forward to both the Planning Commission and you folks at your workshop, hopefully in October. Another piece of the public involvement plan that we've been working on very diligently, and is a good source for all of the information that we are putting together for this plan, is our webpage. In fact, I'd like to share my screen and show you how easy it is to access this information. We do have our City of Oak Harbor web homepage, essentially. Under latest news, we have Housing Action Plan. We do have a brief overview of what the action plan is. We can look at the executive summary, which goes into a little bit more detail. And then at the end of this 2-page introduction, we have this page, which actually is the one that LDC has put together and will be the landing page for all of the information that we are compiling for this housing action plan. So it's a matter of just a few clicks for you to take a look at what the information is, what the schedules are, some of the public meetings that we will have scheduled. So that was a nice piece to have available for our legislative group, the Planning Commission, as well as our citizens. So like I say, the housing needs assessment probably will be the big piece that will come forth to you. And hopefully that will, ideally, that will identify some gaps in our housing structure and housing market that we can focus some recommendations and strategies to fill those gaps, which would be the second piece of the housing action plan. So with that, I'll conclude my presentation. CAC, you've been part of this all the way through the effort so far. What would you like to add?
Thanks, Dennis. Just want to chat a little bit about the stakeholder meeting. During the COVID time, we had one of those telemeetings. We didn't have all the members attend, but we had a fairly good attendance. And the discussion was very good. I think Dennis covered a little bit of those topics, but I was really happy. We had almost a couple-hour discussion, talked about various topics, and got good information from the building industry on what they're seeing in real time, the challenges that lies ahead in terms of housing, and the challenges that they see, as Dennis mentioned, in regulatory options that they have. So I look forward to the next stakeholder meeting. I think that'll give us more information. The housing needs analysis will match up. Hopefully we can compare what the data tells us to where our opinions and outlook is, and hopefully we'll find the solutions to what we want in terms of housing in Oak Harbor. So with that, I'll just leave it up to the council for questions and comments.
So we have a question from Mayor Pro Tem.
Thank you, Mayor. CAC or Mr. Lefevre, have you contacted the Navy? Because they are not building, to my understanding, any more housing in their housing areas. And I know that they want everyone or requiring within limits that everyone live within 45 minutes of the base. And so has anyone contacted them on how many housing or houses, apartments, whatever, multifamily townhouses that they feel that they need for all their personnel instead of living in Cedar Woolley or Arlington or, just a question. Are they one of your stakeholders or could you please make them to be one?
Absolutely. We do have our Navy contact, Brian Tiehouse, as part of the stakeholder group. And he was unfortunately not able to attend the first meeting, but he is in touch with us. And they are sharing a lot of information on some of their planning that they are doing for housing and for other facility improvements that they're doing on the base. So we have had actually some questions come from the Navy in terms of providing additional housing here by the seaplane base. Not sure where they are in the process, but they are tossing some ideas around in terms of moving facilities, moving the Clover Valley School, and they're considering a lot of options in terms of where they want to move some of those facilities and whether they want to have some additional housing units built. So I don't think anything has been confirmed, but they are sharing that information with us and getting our initial feedback on some of those ideas. And we've been sharing our policies, comprehensive plan policies and opinions with them on that.
Thank you very much. I appreciate it. And your staff for working on this.
Councillor Wiesner.
Thank you, Mayor. A couple of comments and then maybe a question for staff. I just wanted to share, the real-time struggle that is going on in our community. I just went through another weekend as a real estate broker, listed 3 homes, multiple offers on all of them. Obviously we were able to make 3 families happy by accepting their offers, but I also had to make 14 phone calls to agents to inform them that their buyers did not get a house. One of those agents shared with me he had written 11 offers over the weekend and not a single one of his buyers were able to get their house. All of them were either at or above asking price. We're in a bit of a crisis. The struggle is real. It's gotten worse with what's going on with the pandemic. But I know personally of one buyer who's made 6 stabs so far trying to buy a house, all at or above asking price, and is yet to be able to buy a house. So, I'm hoping some real good comes out of this. This is a project that's been going on for a couple of years. We had the task force, that discussed a lot of these items, and I know that you guys are not tossing that stuff out. I know you're using that as a springboard to help move this forward. You've got some of the same folks represented here. Valley High folks and stuff. So certainly, those discussions need to continue. We have a problem in our community, and it's only getting worse. And I got to tell you, the last 30 days has certainly been the worst that I've seen in my career as far as the number of families who aren't getting accepted for offers. I mean, it's just a continuous. So that's my comments. Now, with that said, we all know that out of this housing needs analysis, part of this is we're hoping with this action plan is that we're going to have a plan as to how we can help with the housing needs that is going to come out of this. And buildable lands analysis was an area that we were kind of hung up on for a while, because obviously if we identify housing that's needed, part of our city's job is the next thing is figure out how do we fill that as a city? How do we fill that need as a city? As the Growth Management Act has told us, as a city, we're responsible for taking the density that's required to
alleviate the strain on housing. How do we fill that need? Where are we at with buildable lands analysis? How are we connecting that into this housing needs analysis? And then furthermore, where are we at with the discussions with the county in at least talking about the JPA line? Because that's obviously going to have to be probably tied into this. And if we don't get ahead of that curve, we're going to have all this great information, this great plan, and this great data to move forward, but our partners won't be at the table with us. So that's just my thought strategy moving forward. Looking forward to this information. I think it's going to be real valuable, but we're going to need our partners at the table here real soon to be able to make the heads or tails out of any of this, or be able to do anything about any of this.
Absolutely. Good comments. I like how you tied all of the data to how we have to work with the county. We do have Island County representatives with our stakeholder committee, and we expect them to stay involved. Therefore, we hope that they have connections in the county to transmit that information. And we are going to be working with the Island County on the JPA discussion. That is on our comprehensive plan docket and will stay on our docket, and therefore we will continue to ask the county in terms of where the status is on that. So that will be in front in terms of our discussion. So hopefully with the housing needs analysis, we will have the data. Hopefully we will know how to approach providing that housing. We'll have some hopefully good solutions. I have a feeling that part of that solution is going to involve the county, because it's just not our isolated issue in terms of housing. It's a regional and state issue. And so I think it'll all come together, hopefully, with this housing needs analysis and the actions that need to be implemented after that.
Thanks for hanging in there and keeping on it, CAC. I know it's been a long road, and hopefully we can see some results out of all the hard work. I know staff, we've been hounding on this thing for a while, and I know staff has really been, kind of having to work the upstream, against the regulations and stuff that are, kind of holding some of us back. And I appreciate you guys hanging in there. It's important for our community. It's important for the city that we grow appropriately and meet the needs of the folks and do it with a lot of forethought. And I know you guys are working towards that end. I appreciate it. Absolutely.
We want to rely on data, and I'll just give you an example of something that I heard. We had the Department of Commerce that provided this grant money to Oak Harbor for the housing needs and for the housing action plan, has provided grant dollars to other communities as well. And so they have like a quarterly meeting with all these grant recipients. And so you get to hear ideas from what other communities are doing with their grant. And so you can borrow and share ideas from each other. And one of the nice things I heard is for one of the communities, they were able to do an analysis, and they could narrow down how many affordable units they need for the population they have. So if you do the data analysis and you do the income analysis and you can narrow down the population, you can get to a very specific number, really, which was surprising. I'm like, all right, now you have a goal. You have something that is quantifiable that you can try and strategize. So I don't know how the data will show, what the data will show for Oak Harbor, but I'm hoping that we have something like that that's very definitive that we can work towards, and everybody will be able to understand what we're working towards.
So Councillor Goebel has a question.
Thank you, Mayor. I actually don't want to ask my questions anymore. CAC answered them throughout his dialogue with Jim, so I'm all good.
Okay.
But thank you. I'm looking forward to hearing the information.
Absolutely. Thank you.
Anyone else? Okay. Thank you, CAC, for that. Then we'll move on to item B, Shoreline Master Program Periodic Review Progress Report. CAC, back to you.
This is thank you, Mayor. This is an effort that we started quite a while ago in terms of updating our shoreline document. As part of that, we also have consultants hired to look very closely at the Bluff Conservancy designation. So that work is also ongoing, and I will transfer it again to Senior Planner Dennis Lefevre to give us an update on that. Dennis?
All right. Thank you, CAC. Welcome again, Council. As I've mentioned in several previous discussions on the Shoreline Master Program and our periodic review requirement, there are three required pieces that we look at as part of this update process. And one you've had an opportunity to review, and that was the checklist that the Department of Ecology has prepared regarding all of the amendments that have been made to the Shoreline Management Act and some of their rule changes that have occurred since our last update to the SMP, which was, adopted by Ecology in 2013, the city adopted in 2012. So we've looked at those amendments through the course of the years and incorporated where we felt it was necessary to make amendments to our current SMP, or if not, then we did not make any proposed amendments. The other piece is to include new information, updated information, and CAC has mentioned that our consultants, Coastal Geologic Services, are looking at the Residential Bluff Conservancy designation to make sure that what policies and regulations we have in our SMP and our Oak Harbor Municipal Code are sufficient to protect that very delicate balance between the bluff and the development that is the option of the property owners. So we'll be looking at that. I suspect we'll have some information that we can present to council hopefully early this fall. That's our time frame with the consultants. We're also going to be looking at how potentially sea level rise will impact some of the issues that we deal with in the Shoreline Master Program, whether it is a no effect, modest effect, or potentially severe, which I don't expect. We will have to address it somehow in our Shoreline Master Program. I think it'd be problematic if we didn't address it somehow. And of course, the other piece that we need to address is consistency with our local and regional comprehensive plans and our development regulations. The document that was attached to your packet is a draft of my response to that consistency review. As you notice, I've included 16 local and regional plans that deal or have some overlap with the influence of the Shoreline Master Program, and have indicated, have given a brief background of each document and have determined whether it's been consistent with our Shoreline Master Program, and if not, what type of recommendation we could make to make it consistent. In most cases, I found that those local and regional plans have been very consistent with the existing policies in our Shoreline Master Program, so I don't expect many amendments coming from that review. The other piece of that, of course, is the development regulations. That's a little bit later on in that document that's part of your attachment. We had quite a few development regulations that have influence within the shoreline jurisdiction, including the critical areas ordinance, low impact development. We had some modifications to our floodplain protection ordinance. So we've looked at those and have included some amendments to make sure that we're consistent with those new regulations as well. And those are all identified in that document. So that's essentially all I had to report today. Certainly would be happy to answer any of your questions. In the months to come, I hope to obviously deal with the third piece, which is the updated and new information, but then also pull this all together in a draft document that you will have ample time to review. So that'll be something you can look forward to this fall, later this fall. So with that, if you have any questions on this consistency review, I'd be happy to answer those.
Okay, doesn't look like it. You covered that very well, I think. Mr. LaFever, thank you.
Thank you.
Okay, at this point, we'll move on then to our next section, Administration City Administrators Report. So, Mr. Oborn, you have a few pages in the packet.
Yeah, a few pages there. I appreciate this opportunity. I'm going to try to do it with my mask on. If there's an issue with understanding me, let me know, and I'll go ahead and remove my mask temporarily while I give this presentation. First of all, I want to start off on the positive note. I'm on my 2 years with the city, so it's gone by really fast. So it's my pleasure to be the city administrator for the last 2 years, and I think we made a lot of accomplishments there. It's great to hear the presentation by WCIA, Wisconsin Cities Insurance Authority. I am the city delegate on that. I've served as a delegate in that capacity at other municipalities in my experience, and I know that they are a great organization to work with, and I'm very happy with how they function and the service they provide us, and it certainly warrants following their advice. Going on to my report here, Arts Commission, I just gave a number of updates there. Any questions, you can let me know at the end or contact me personally. Legislative outreach, I participated in the, I said there August, but now, or July, but now I've participated in the August COG. Ironically, they talked about, today's discussion was about housing and affordable housing, and I did advocate for the JPA and UGA because I know there's been some resistance and some possible postponement of that, and certainly I appreciate Councilor Wiesner's comments there and bringing them to the table, and the county needs to recognize that they're a partnership, and certainly availability of property that's controlled by the joint planning area for JPA and the urban growth area, to help some people who might be new on the council here with those acronyms that we use very readily, and it's part of the Growth Management Act of the GMA that has a lot of effect on housing, and some of it's adverse. It goes against helping out with, and so we're trying to figure out how we go to against the tide there. But certainly it was my pleasure to represent the city there and advocate for council's directives in those areas. Moving on to Oak Harbor Main Street there, it's been a long, the Main Street came up with two large signs some time ago, actually 3 directors ago. So it's finally been installed in Peaksma Park, one of the 2 signs that were fabricated to highlight the downtown. So I certainly want to thank, it took a lot of staff time in parks, engineering, and streets to really make that happen, and to partner with them and get that installation of that sign. So I certainly thank the staff for the efforts there in showing our partnership with the Main Street and completing that sign. Moving on to the CARES grant, we are moving ahead with finally getting into the processing of payments. So that's where we're ultimately helping individuals and our businesses that are affected by the shutdown of businesses. So glad we're moving ahead in that area. The next area I'm kind of involved in is the broadband county feasibility study. So that's near the completion, and I'll look at how I brief the council on that and bring back that plan, and certainly hopefully that moves forward and is kind of creating a consortium with the municipalities and cities and looking at how we continue to advocate for broadband and kind of use some of the models that some of the other counties have done. We'll be paying the payment there, but the Coupeville Port Authority has been the lead agency in this countywide broadband study, and so we're matching funds of $5,000 will be coming forth on that area. Anacortes wet fiber, you're kind of familiar with that. We've had it on the council agenda twice and got pulled off, so I think we're hoping that we get the language finalized and we get it on an upcoming agenda really soon to talk about the wet fiber coordination with them. So great project. Moving on to communications, continue to do the mayor's snapshot, something I started, and then our new PIO, when she came on, is something that she's really advanced and improved upon, and I certainly appreciate her efforts there. Then also, the area that communications is working on chamber promoting the open air Thursdays and creating a proclamation to assist businesses during these events. So we kind of expanded it a little bit as we figured out ways that we can help businesses during these in the recovery effort. Moving on to information technology area there, we are doing staff weekly meetings to really track the scope of the work and track the project and to get some major projects that have kind of been put off and trying to prioritize them and get them accomplished, and we'll have more updates coming up on that in the future. Certainly, you're aware of the newly hired director, David Cole, starts on Monday, August 31st. So, and in the interim, I certainly, you saw CAC in action there tonight, and yesterday I attended the Plan Commission meeting, so I continue to appreciate his leadership during this interim time as the interim Director of Development Services. So thank you, CAC, there. And then Housing Action Plan was on the agenda already tonight. And then on to lastly, on the Finance Director, we will have our interim Finance Director at our meeting on September 1st, discussing a number of items and utilizing him in that function. Moving on to HR, Hankton items. There's should see an email going out about a celebration on him, COVID style, on this Friday. So look for that invitation there to thank him for his 37 years of service with the city. So certainly, it's been my pleasure to work with him for the last 2 years, and wealth of knowledge and just done an outstanding job. And certainly we're working on trying to replace him, but in some ways it's irreplaceable with all the knowledge he has. So, and then also another retirement to celebrate is Don Bear, and the fire captain in 17 years of service is retiring on September 30th. Recruitment, the finance director interviews or first round are scheduled for this Friday, and Mayor and I and one council member will be participating in that. And then training, we'll continue our efforts in citywide training regarding team building is coming forth. Moving on to the next page, the marina business is actually up according to our harbor master from last year. So interesting dynamics there with the closure of the border and such, but it's certainly benefiting us right now despite COVID. Police department, certainly there was a lot of discussion on body cameras. We committed to giving you an update on that, and the chief has gave you the latest here as of when he wrote this a few days ago. It might have changed a little bit, but hopefully he's proceeding with trying to do it without the TAP program and then cutting the cost down to around $90,000. And then Yakima with the COVID issues has changed some strategies there. So we're not utilizing them anymore, but the chief feels that he can transition without that and absorb the change in not using Yakima anymore. So that's moving ahead. And then Public Works, I continue to take the role of being the direct person on that area. And so certainly we appreciate the council's approval of the extension. And so we're in the process of doing the letter to the Navy on that. And one of the things when the group met is we wanted to add some language in there that really encourages the Navy to give us a real substantial or meaningful offer by October 1st. So to really push them along, because really to make this thing happen, they can't really throw it on us on December 20th. We really need it ahead of time. So we're going to kind of really strongly advocate them to give us an answer earlier rather than later. So, and then also we have our meeting tomorrow with them at and appreciate the group that participates in that and a team effort in advocating for the city. Moving on to engineering, waterfront pedestrian improvements that's now completed, as I got an update on that one. The Passaic Vault is scheduled for September. Got a little bit more definitive information on that one. Streets, exciting work there with the TBD money, Transportation Benefit District, additional sales tax that was passed in November, thanks to our citizens, and that work is proceeding there, is in process right now. Moving on to Parks Division, the regional park proposal there, the Harbor Heights property that we purchased is proceeding, and staff is working with the firm on the geotech. And then lastly, the Senior Services Center bus was sold in auction for $15,100, and that will stay in the Senior Center fund to be used for other projects related to senior services. With that, I'll answer any questions anybody has.
Mayor Pro Tem.
Thank you, Mayor. Mr. Oborn, I noticed that there was some reclassification done. Now, has there been any adjustment in their salaries for that? Angela Rhinestone is reclassified from administrative assistant to senior administrative assistant for fire. And then the evidence specialist, I believe Chief Dressler talked about that. But is there any increase in their salary, or just stays the same? We're just retitling their positions to narrow down or expand the scope of what they do?
There is increase in salary, yes.
Okay, so can
I
we
give input?
know what that is? I mean,
Well, I can speak
that
to,
has to do with the budget and when it takes place, please, sir?
So let Chief, looks like.
I'll let the chief, go ahead, Chief Dresker.
Yeah, just to speak to the one at the PD, there's actually a reduction in salary, and that employee sought us out, and so ours was actually reduced, not an increase with salary through our changes. Our changes included a reduction and a little realignment, so that was the PD portion.
And there was no problem? I mean, I don't know, if you counted, if you're planning your budget with mortgage and bills or rent and stuff like that, and suddenly you're getting a reduction.
No, there was no problem. It was handled properly and a well done process.
Thank you, sir. I appreciate it. You're usually very thorough before you have action. You've looked at all the angles. Thank you.
So I think, did that answer? I think that in the other case, we did have an increase, but
It's a slight increase, but it's absorbed in the budget by the fire chief.
okay.
Okay, just wanted to know if it's sustainable. I mean, I love it when people get raises, but we still don't know exactly how much revenue we're going to be down this year. Not as much as a lot of cities, but I'd hate for someone to get a raise and then have to be taken back because it's not sustainable.
Thank you. That's certainly true. We need to be cognizant of that, and I want to give our department heads some credit here, because at each weekly meeting we have discussions about, often have discussions about staff, and I know that they are very concerned about the ongoing pandemic and the effects that has on their budget, and we've got department heads that are working with solutions, finding solutions in light of the pandemic, and I'm just, my hat's off, because they're just talking about it and working on it continuously. So did you have?
I mentioned on cost savings on that area. We continue to look for cost savings there. We continue to vet any openings we have to see if we can potentially leave that vacant. And so we've been innovative with the hire that we did in the senior services. We're using county COVID money to pay for that position as that person, instead of working in the senior services, works on the CARES funding. So it's really a win-win.
So any other council business or questions? I think I should have, from the very beginning, should have stated, I think we've got pretty much our full council in attendance except for Councilor Mack. I believe that's the case, right? Yeah, I'm sorry, we didn't do a roll call, but we don't normally at workshops, but usually we do introduce those that are here on council. So thank you for your time. And we're going to be done this afternoon before 5 o'clock, so that's about the time we usually start these meetings. So thank you for that too. Seeing no other council business or input, we'll adjourn this meeting. Thank you very much and be safe out there.
Thank you, Mayor.
Thank you.